So, based on the video presented just now, there are 3 issues that can be extracted from the question. So take note everyone, it's important for you to identify the correct issue. Now, from this slide, we can see that there is definition of land. So the definition of land can be seen in the section 5 of the National Land Code. Nevertheless, the relevant subsection in this situation is subsection D. Hello, Miss Amirah here. Now we'll be discussing about law of fixture and chattel. It is crucial to discuss or highlight the law of fixtures. The general rule of fixture has been expressly stated in the case of all land against Hodgson, which it illustrates that all things attached to the land or any item fastened to anything attached to the land falls within the definition of land. This case also laid out 2 tests, which are the degree of annexation test and also purpose of annexation test. The genre also in line with the maxim where it highlights that whatever is affixed to the soil belongs to the soil. Lastly, the definition of fixture and chattel can be looked into bullet number 4, where fixture is when an item is attached to the land and immovable, while chattel is an item even when it is attached to the land but it is removable.
In order to apply the degree of annexation test, we need to look through the question to what extent the item is attached to the land. So whether it is strongly attached or slightly attached to the land, or if it's just weighing with its weight to the land. And to check to what extent this item is attached, we need to look through the several criteria, such as will the removal of the item cause a damage, and whether this damage would be a great or a slight one. And the next question is, how do we apply the degree of annexation test? So if upon removal of the item there is a great damage, then it is prima facie considered as a fixture. Also, if it's foreseeable that the item will cause great damage, and also that it will reduce the amount of the property, so this indicates this item is also prima facie a fixture. So in general, we have to refer to such criteria as the level of attachment to the land. The more the item will be considered as part of the land, the more it's likely to be a fixture. However, the test of degree of annexation test is not a conclusive test, and we need to refer to the next one as well. So the next test is the purpose or object of annexation test. In order to apply this test, we should refer to several cases. The first one is the Holland v. Hodgson. In this case, the court held that once the loom was attached with the nuts and bolts to the mill, it is considered as a fixture. Why? Because it was directly aimed for the operation of the factory itself. In the second case, which is called the Chalko-Hin v. the Consolidated Molle of Rubber, it was held that the purpose of the permanent annexation of the item was considered of a paramount consideration. And in the third case, which is called the Chalko Federation of Malaya Ltd, the subject of the question was the 10 of oil. And in this case, the court has held that it would consider it as a fixture because it was buried underground, and the removal of this tank of oil would cause the damage both for the land and for the tank oil as well. So in order to find out whether an item is considered a chattel or a fixture, we need to ask a question whether it is intended to enhance the value of the land. So if the item enhances the value of the land, then it is considered a fixture. So we can refer to the case. Its name is depicted on the slide, and in this case the court was of the view that the equipped air conditioners are fixtures because the removal of them would cause great damage to the company, and actually this company was a shopping complex and it would be useless without these operating air conditioners. And also we need to ask a question, is it for better use of the item as a chattel itself? So we also can refer to the case Line and Company v. London City and Midland. In this case there was an argument that the chairs were fixtures. However, the court held that since the annexation of the chairs were of a mere purpose and for more complete enjoyment, therefore the chairs were considered as chattels.
Now we move on to the exception to the general rule. There are two cases that we use for this matter, which is the first one is the Sungai Way Leasing Sudan Berhad, and the second one is the Wigan State Malaysia Sudan Berhad. Okay, so the relevant exception for this matter is the written agreement concerning charger and chargee. There are two elements that must be proven to establish the exception, which are acknowledgement and insertion of an express terms. Another case in this matter is the Sungai Way Leasing Sudan Berhad case. We have concluded that if there is no disclosure of the agreement, then such acknowledgement can be inserted into the agreement entered between the charger and the third party, specifically by inserting a retention clause, expressly and plainly. In the case of Wigan State Malaysia Sudan Berhad, we have stated that for acknowledgement, the charger needs to inform the chargee that there is an agreement entered between the charger and the third party concerned regarding the items in dispute, so that the chargee can be informed and acknowledge the fact.
Next, we'll be looking into Malaysian application of law of fixture and chattel. So even though the definition of fixture and chattel is not expressly stated in the National Land Code, but the judgment in the case of Kok Chok Hin against Consolidated Malay Rubber 1924 stated that the English law of fixtures is applicable and referred in Malaysia. Therefore, the law of fixtures highlighted in the case of Holland against Hodgson can be applied.
We shall now move on to the application part. Before we go on to the application part, these are the items in dispute. Firstly, an 8 unit of custom-made air conditioners. Second, 3 washing machines. And lastly, 20 sewing machines.
Hello everyone, I am Miss Nisa and I will be explaining on the application of this question. The first issue is whether Abu can remove the 8 units of custom-made air conditioners as chattel. In determining whether the air conditioners are fixtures or chattels, the first test laid out in the case of Holland against Hudson must be scrutinized. In this situation, in determining the degree of annexation, we must look at two things. Firstly, the level of attachment of the air conditioners to the factory, and secondly, we must also look at the degree of damage caused if the items were to be removed. Since air conditioners are strongly attached to the wall of the factory, it can be said that the process of removing the air conditioners will damage the wall severely. With this, it can be deduced that with the custom-made air conditioners were built with the bulky size as it needed to conform with the factory standard, then there will be a tremendous amount of procedures required to remove the air conditioners, subsequently indicating that there might be great damage upon its removal. Moreover, the damage caused will also lead to the decrease in the value of the factory. All in all, since there are great damage caused upon the removal of the air conditioners, thus it proves that the air conditioners are strongly attached to the wall. Hence, the 8 unit of custom-made air conditioners are prima facie fixtures. Ladies and gentlemen, we shall now move on to the second test, which is the purpose of annexation. As mentioned earlier by Mr. Yaroslav, there are 4 questions which must be answered in determining the purpose of annexation. Let us look at the first question. The first question is, what is the purpose of putting the 8 units of custom-made air conditioners in a factory? Generally, air conditioners are used for better enjoyment of the factory itself, as you won't be enjoying yourself if you are hot, right? The next question is, was the air conditioners intended to be permanent? In this situation, since it is a custom-made air conditioners, it can be said that it was indeed being customized for it to be permanent. With that, there was an intention for it to be permanently attached to the said factory. And the third question that we need to look into is whether the air conditioners are for the better use of the item as a chattel itself. In this situation, the purpose of affixing an air conditioner in a factory is to cool down the heat in the factory. If an air conditioner is not installed in a factory, the workers might not feel comfortable upon carrying their duty in sewing trousers. Thus, it can be implied that the installation of an air conditioner in a factory is to provide for a better enjoyment. In other words, even if the air conditioners were not installed in the factory can still run smoothly as it was only for the purpose of providing comfort to the workers. We shall now look at the last question in answering the purpose of annexation. The last question is whether the installation of the 8 units of custom-made air conditioners enhance the value of the land. In this situation, a custom-made air conditioner cannot be said to enhance the value of the land, as the purpose of installing air conditioners in the first place is specifically for the better enjoyment of the workers involved. One case to illustrate this situation is the case of Sungai Lazing Sdn Bhd. As you can see from my right side, the air conditioners in dispute were regarded as fixtures as the item can enhance the value of the land as a shopping mall. Comparing our situation to the case of Sungai Wei, the absence of the air conditioners in this question would not render the factory as useless, since air conditioners does not contribute in the operation of the factory in producing trousers. Unlike in Sungai Wei, where it is indeed important for a shopping complex to have air conditioners. Therefore, since the purpose of installing the 8 units of custom-made air conditioners does not enhance the value of the land and only provide for better enjoyment, thus the air conditioners in dispute shall be regarded as chattels.
First, we will look into the degree of annexation test and discussing whether the washing machines are permanently fixed or chattels. The attachment of washing machine to the hostel must be taken into account. In this case, the washing machine are resting by their own weight in the hostel and they will be placed in the utilities room. Hence, no additional support or fastening are needed in order to increase the stability of the washing machine or prevent the washing machine from moving, since they will be placed in a confined space. Since there are no additional fastening used to attach the machines to the hostel, as they were only rested by their own weight, it proved that the washing machine can be easily removed. Pursuant to this factor, it can be seen that the washing machine are not strongly attached to the hostel, subsequently indicating that they will not be part of the hostel. Therefore, the washing machines are prima facie chattels. Next, we will look into purpose of annexation test. Firstly, purpose of putting washing machine. The purpose of putting the washing machines in the hostel is for the better enjoyment of the workers and to ease the process of washing their clothes. If there is no washing machine installed in the hostel, the workers can still wash their clothes. Secondly, intended to be permanent. The washing machines are not intended to be permanent since they are not directly attached to the hostel. Furthermore, the purpose of the washing machine is only for the better enjoyment of the workers. If there's no washing machine installed in the hostel, the workers can still wash their clothes. As referred to the case of Sungai Wei, it can be said that the installation of the washing machine is not important to the hostel, since the absence of the washing machine doesn't make the hostel exist. Thus, the washing machine are not intended to be permanent. Thirdly, enhance the value of the hostel. The washing machines do not enhance the value of the hostel, since the fully automatic washing machines are only to ease the worker to wash their clothes. Other than that, the workers can opt for other alternatives to wash their clothes besides using the washing machines. In other words, the washing machines are not crucial to enhance the value of the hostel. Therefore, the washing machines cannot be said to enhance the value of the hostel. Lastly, better use of the washing machine as a shutter itself. Even though the washing machines installed in the hostel are fully automatic washing machines, they are only for the better enjoyment of the workers, since they are only there to lessen the burden of the workers to wash their clothes. In conclusion, since all conditions are not fulfilled, therefore, the washing machines can be regarded as shuttles.
Ladies and gentlemen, let us now move on to the third issue. The third issue is whether Senyum Bank can claim the 20 sewing machines. In order for Senyum Bank to claim for the sewing machines must be chattels and not form part of the land. In determining that, let us look at the degree of annexation of the sewing machines. The sewing machines in this situation can be regarded as prima facie fixtures, as the sewing machines are attached to the floor of the factory with bolts and nuts. This indicates that the process of removing the sewing machines will cause great damage to the floor of the factory, as it will require more strength to detach the nuts and bolts from the sewing machines. As there were 20 sewing machines affixed to the floor of the factory, it is foreseeable to infer that the floor is likely to be cracked, subsequently affecting the structure of the factory's floor, as well as decreasing the value of the factory. All in all, since the removal of the sewing machines can cause great damage, this proves that the sewing machines are strongly attached to the factory and can be regarded as prima facie fixtures.
Moreover, the process of removing the sewing machines will cause great damage to the floor, as it is attached with nuts and bolts, which will require more strength for it to be removed. Therefore, the sewing machines can be regarded as prima facie fixtures.
Let us now look at the purpose of annexation of the 20 sewing machines. The first first question is the purpose of affixing the sewing machines in the factory. In this situation, the purpose of affixing the sewing machine on the floor is to help manufacture trousers in the factory. Since the factory functioned in manufacturing trousers, it can be deduced that the machines were essential machineries for the purpose of manufacturing those trousers. The second question is, was the sewing machine being attached to the floor of the factory was intended to be permanent? First of all, the sewing machine being attached to the land was intended to be permanent, as it has been affixed with nuts and bolts on the floor. The usage of nuts and bolts will strengthen the attachment of the sewing machines on the floor, and the removal of such machines might cause great damage to the factory itself. It would be rational to say that Abu, as the owner of the factory, would not use additional fasteners such as nuts and bolts to attach the sewing machines on the floor if the machines were not intended to be permanent. Thus, it proves that the sewing machines were indeed intended to be permanent.
The third question which must be asked is whether the items can enhance the value of the land. In this situation, the sewing machine does enhance the value of the land, as the reason why it is being attached is to help the factory to operate in producing trousers. In other words, if the sewing machines are not attached to the factory would be useless. Meanwhile, as for the last question, whether the sewing machine is for the better use of the item as a shuttle itself, in this situation, the sewing machines are not for the better enjoyment of the item as a shuttle itself. This is because without the sewing machine being attached to the floor, the sewing machine cannot be fully utilized. All in all, since the sewing machine does enhance the value of the land and is not for the better enjoyment of the item as a shuttle itself, it can be said that the sewing machines are fixtures.
As you can see on the slide, there are some exceptions to the general rule, and the first element of this exception is the acknowledgement. So, in fact, if the Senior Bank wants to claim for the sewing machines as chattel, then Senior Bank must prove that Abu, as the charger, has informed the BINTI Bank at the time the charge was made, and that he had already had a hire purchase agreement with the Senior Bank for the sewing machines. However, as this was not the case in our situation, then the sewing machines would still be passed to BINTI Bank despite the existence of hire purchase agreement entered between Abu and Senior Bank to show that a charge was established. So basically, the Senior Bank may be entitled to claim for the sewing machines if they can prove that a retention clause was inserted in the hire purchase agreement. However, in this situation, if a retention clause is provided in the hire purchase agreement saying that the sewing machines cannot be charged to any parties, then those sewing machines could be regarded as chattel. But however, in our present case, there was not retention clause stated by the bank, and it did not expressly or plainly stated in the hire purchase agreement between Abu and Senior Bank. That's why the sewing machines are fixtures, and thus they form part of the land.
All in all, for the first issue, 8 units of custom-made air conditioner are chattels. Thus, Abu can claim the air conditioner. For the second issue, 3 units of fully automatic washing machines are chattels. Therefore, the workers can claim back for the washing machines. Lastly, for the third issue, 20 units of sewing machine are fixtures. Hence, Senior Bank is not entitled to claim the sewing machine.
Now we move on to the second limb of the question. The issue is whether Abu can take legal action towards Bakar to the damaged store suffered by Abu due to the excavation of Bakar's land. The law for this topic is stated under Section 44, Subsection 1, Clause B of the National Land Code. Landowner is entitled in certain circumstances to have his land supported by the neighboring land and right not to have the support removed. Also remember, there are few conditions that a landowner need to fulfill in order to entitle to the right of support, which is the first one is the land at the lower level must support the land above it. The second one is the land must be adjoining to each other, which is the next to each other. The third one, the land is in a natural state where the land is free from any excavations. And the last one is there is no additional support or strength to be given beyond what naturally had. Now we move on to the cases that we use in this question, where the first one we use the Madam Chasiam case and the second one we use the Guan Sunting mining case. Both of the cases portrays the same principle of the entitlement of the right of support of the land, where a landowner's land has been damaged with the land adjacent to it. The landowner argued for the land of support entitled to him but not managed to have the support because of the condition of the land is unnatural. Now we already explained the law, now we are going to apply. Abu's right to his land is protected under Section 44, Subsection 1, Clause B of the National Land Code, because based on the section, it already safeguards the right of support towards Abu, where the right of support allows Abu, where his land has been damaged by Bakar, where he excavated his part of the land. I have stated earlier there are conditions that a landowner needs to fulfill in order to entitle the right of support. Now, we are going to apply to Abu. So for the first one is the land at lower level must support the land above it. To apply, land owned by Abu does not have any support from either the lower level or the land above it, seeing the condition of the land is not a hill or a mountain. The only land that adjacent to Abu's is Bakar's land, so the first condition is not fulfilled. Next, for the second condition, is the land must be adjoining to each other. To apply, Abu's and Bakar's land is adjoined next to each other. Then, the second condition is fulfilled. The third condition is the land also needs to be in a natural state, where the natural state of the land is unburdened by a building and unweakened by excavation. To apply, land is not in a natural state as the land was excavated by Bakar. So, the third condition is not fulfilled. The fourth condition or the last condition that Abu needs to fulfill is that there is no additional support of strength to be given beyond what the land naturally had. To apply, Abu's land does not contain any additional support in his land, considering the land is not in a natural state. By that, we already concluded that all the conditions has been fulfilled and not fulfilled by Abu. As those two cases that I have stated earlier, which is the Madam Chasiam and Guansun cases, we are going to apply that Abu does not have any right to take legal action towards Bakar because of the condition of the land that Abu's had, which is unnatural. The land was unnatural because it has been excavated by Bakar. Even though his part of the land has been excavated, which results in Abu's land collapsing and his stores is damaged, he still cannot sue Bakar for his act. Now we have come into a conclusion that Abu cannot take a legal action towards Bakar because he did not fulfill all the conditions that need to fulfill in order to entitle the right of support. Now we can see that in order to entitle the right of support, all conditions needs to be fulfilled, and Abu did not fulfill the conditions.
Thank you for watching TVU.
Have any question bothering you? Solve it with TVU.